So,
We go to the second part of the enactment called maintenance of wife. Section 18 provides saying that if the wife is deserted and she is abandoned and left to the skies and she has no independent means of livelihood and she has no earning capacity, then she can ask for what is called maintenance from her husband. The second ground is cruelty, where the wife has been subjected to physical and mental cruelty, mental torture, and she is unable to live with the husband, then she can ask for maintenance. The third ground is the husband is suffering from a virulent disease of leprosy, which is communicable and which is not curable. Then that is the third ground on which maintenance can be asked. The fourth ground is if the husband has suppressed the fact that he had already a wife living and suppressed that fact at the time of marriage and she was induced to get married to the person concerned, then that gives rise to a claim of maintenance. And then next one is suppose a person is living with a mistress or living with a concubine, then in that case that's also one of the grounds of asking maintenance. Then suppose the husband has got converted into another religion, ceased to be a Hindu, that also is a ground for maintenance. Or there are some justifying grounds on which the wife is justified in living separately. All these grounds are available for the wife to claim maintenance from her husband, or what is called manavarti or nafka from her husband. Then AR 2005, Supreme Court 996 says right of residence also is part of maintenance. So the question is, just by paying maintenance, you cannot get away. The wife should be provided accommodation somewhere where she can live. And even that, apart from the maintenance, the husband is bound to provide residence also to the wife. Then 18 and 20 is so as far as interim maintenance is concerned, as laid down in AR 2004, Supreme Court 3453, interim maintenance of Supreme Court will not entertain any appeal which grants interim maintenance before the lower court or the high court, and such an appeal is not maintainable in the Supreme Court. Then we go to section 19, which deals with the right of widowed daughter-in-law to be maintained. Suppose the daughter-in-law loses her husband and she is dependent upon the family of her husband. She is living with the father-in-law. Then the father-in-law is bound to maintain the daughter-in-law subject to his means. And this is what was laid down in AR 2016 Chhattisgarh 185 division bench. So the father-in-law is bound to maintain the daughter-in-law who has lost her husband and out of the estate she has to be maintained, and the question is subject to the means available with the father-in-law. The daughter-in-law has got a vested right of being maintained. Then we go to maintenance of children and aged parents, legitimate or illegitimate, and parents. So now we have got a separate enactment called the Senior Citizens and Maintenance of Senior Citizens Act, which says even the aged parents will have to be maintained by their children. Here, the question is now the BNSS also has been amended, where there's a previous section 125, it only talked about the wife. Now the aged parents are also included there, but you have got a separate enactment called the Senior Citizens Act, under which the parents have to be maintained. In this regard, I would like to cite one instance in Maharashtra. What happened was a father got his daughter qualified, he got her educated with the sweat and toil, and then the entire resources was spent for the daughter who became a doctor, and she became a prosperous doctor, and she subsequently got married. Then the father was unable to maintain himself. He said, whatever resources I had, it has got drained. I do not have any son, or I do not have anyone except my daughter. She is bound to maintain me. The daughter took a stand, saying, sir, I am only a daughter. I have got married to another person. I have acquired the surname of that family. I cease to be a member of this family. And if my father does not have a son, it is not my headache. He has to maintain himself, steal, beg, or borrow. But the High Court in this particular case said, don't be so ungrateful. Your father has spent his entire savings in getting you educated, getting you married, getting you well placed in life. And when he says that he does not have means to maintain himself, it is your duty to maintain him, and it is your duty to pay him maintenance. So, irrespective of a female or a male, they are bound to maintain the aged parents. Here, one more thing you have to remember. In one more case, what happened was a 77-year-old son brought an action against the father, who was 99 years, asking for maintenance, claiming inter alia that he does not have means to support himself. And the father contended, "So I am almost in the last lap of my life. I am 99 years old. My son is 77 years. I am not bound to maintain him." But the courts in this case said age is not the criteria. Only criteria is whether it be a son, whether it be a daughter, or so on and so forth. If they are unable to maintain themselves, maintenance can be awarded. Then, sir, we go to section 21. And one more thing. Here, children also has to be maintained, illegitimate or legitimate. The question is, aged parents also have to be maintained. Now, the BNSS also has made it clear that aged parents also have got a right of claiming maintenance from their children. Then we go to who are the dependents. The section 21 defines who are the dependents: father or mother, widow, his or her son, son of his predeceased son, unmarried daughter, great granddaughter from the estate of her mother or father, widowed daughter, provided she is unable to obtain maintain herself from the estate of her husband, or from her son or daughter or father-in-law or his father, from that estate till remarriage. So, father or mother, widow, then her son, widow, her sons, then son of the predeceased son, then unmarried daughter, great granddaughter from the estate of her mother or father, widowed daughter, provided she is unable to obtain maintenance from the estate of her husband, or from her son or daughter or father-in-law and his father from their estate till remarriage. So all these people are dependents: father, mother, son, question daughter, unmarried daughter, widowed daughter, divorced daughter, then great granddaughter, and from the estate of her mother or father, they are entitled for maintenance, provided they are unable to maintain themselves, or the estate of the husband of the daughter is unable to satisfy her claim for maintenance. Then in that case, the till her remarriage, she can claim maintenance. That's what for 21 deals with. Then 22 is where the widow is unable to maintain her children, or she was not having sufficient means from her husband's estate. Section 22 says where a daughter is unable to maintain the children, he does not have enough resources, he does not have sufficient income, and the estate of the husband also is not sufficient to satisfy her needs, then she can claim maintenance from her parents also, and from her parents and husbands, and she can also claim maintenance from her husband's estate. Then we go to section 23, amount of maintenance, position and means of the parties, reasonable wants. Third one is where when they're living separately, just in justification by virtue of the claimant's property. Then they're living separately, justification. Then fourth one is where value of the claimant's property, number of persons, regard shall be had to net value of the estate of the deceased, provision if any made in the will. Then degrees of relationship, reasonable wants, past relationship of the deceased and dependent, value of the property of the dependent and any other income, number of dependents, it may be altered or changed, amount of maintenance. Here, this particular section 23 deals with the amount that can be granted as maintenance. First and foremost is the position and status of the parties. That is more important. Now, that is the reason now it is made mandatory. Whenever you file a maintenance case, you are supposed to file a prescribed form called assets and liabilities, showing your assets, showing your liabilities, and then that is absolutely mandatory now. Without that, your MC will not be numbered. Then reasonable wants. Reasonable wants is you cannot expect you should be made the Maharani or the Maharani of Delhi. The question is reasonable. What is required for a person to live according to the position, according to the status, according to the financial capability of the other side? The reason, what are the reasonable ones, like food, shelter, and clothing? You cannot expect to have food in the five-star hotel every day and make the husband responsible to pay the charges. Or you cannot expect to live in a palatial flat consisting of 5 to 6 bedrooms. Or you cannot expect that you should be provided enormous money for the purpose of your cosmetics and artificial living. These are the facts. Then next is regard shall be had to the net value of the estate. Then, if any provision is made in the will as far as the maintenance is concerned, then degrees of relationship between the parties and reasonable wants and past relationship of the deceased and dependent. What was the relationship of the deceased and the dependent before the deceased expired? And then value of the property of the dependent and any other income and number of dependents, it may be altered. So, all these factors will have a bearing in the court while granting maintenance. The first one is position and status of the parties. Second one is reasonable wants. Third one is living separately and justification for that. Fourth is value of the claimant's property. Then number of persons, dependents. Then regard shall be had to the net value of the estate of the deceased. Provision, if many, made in the will. Degrees of relationship, reasonable wants, and past relationship of the deceased and dependent, and value of the property of the dependent, and any other income, and number of dependents. So all these factors will have a guiding force as far as the courts are concerned in granting maintenance. So here it is not going to be permanent. At any time it can be altered, at any time it can be reduced, at any time it can be enhanced, subject to all these conditions being satisfied. That's what section 23 lays down. Then 24 is claimant should be a Hindu. And first and foremost, to come within the mischief of this particular act, it is compulsory that the party claiming maintenance should be a Hindu. Unless she is a Hindu, she cannot come under this particular enactment. That's what section 24 lays down. Then 25 is amount of maintenance may be altered due to change of circumstance. The maintenance that is granted by the court should be reasonable, should not be abnormal, should not be excessive, should not be exorbitant. But at any stage, when circumstances are brought to the notice of the court, the maintenance can be altered, maintenance can be reduced, maintenance can be enhanced also under certain circumstances. Then next one is, this is what section 25 says. Then 26 is debts to have priority. Please remember what Apollo unnadu. He is due and payable money to many people. Only after the debts are satisfied, minus those debts, whatever is available, from that alone the maintenance has to be paid. You cannot say, go to hell as far as your debts are concerned. I want my money. That cannot be done. That's what is section 26. Then 27 is, it is created by will unless one is created by will of the deceased or by court by agreement. So as far as charge is concerned, charge is not defined anywhere in this act. What does it mean? When the property of another becomes liable to satisfy the maintenance claim or any other claim of a particular party, it is called a charge. That's why when you read charge in the Transfer of Property Act under Section 100, it is said charge can be created by act of parties or by operation of law. The question is, suppose the husband is entitled for 1/4 share in his father's property, the charge can be created to the extent of the husband's share of 1/4 in the property. But suppose, let us say, you cannot claim the entire property and you cannot have a charge on the entire property, but by operation of law, the court says to the extent of 1/4 of the property, that is to the extent of the husband's share in the property, there shall be a charge for wife's maintenance. Or it can also be said that in the will itself, a provision can be made for creating a charge. Suppose an unmarried daughter is there, marriage provision can be made. This property shall be made liable for performing the marriage of the unmarried daughter, to that extent, charge can be created, and that money, which is that property which is subject to a charge, will have to be sold and will have to be utilized for the purpose of marriage of the unmarried daughter, or maintenance of a widowed daughter, or maintenance of a divorcee, so on and so forth. Then the last section under this particular enactment, effect of transfer of property, no right to maintenance can be enforced against the transferee. For suppose, let us say, during the claim for maintenance, let us say the property is transferred, or the right to maintenance is lost, and right to maintenance cannot be claimed or asserted. So this finishes the subject on Hindu law of adoptions and Maintenance Act of 1956. The crux of this enactment is, as far as adoption is concerned, the essential ingredients are that there should be give and take, number one. Number two, there should be competency of the biological parents. Third one is, there should be competency of the adoptive parents. Fourth one is, the minor who is sought to be taken into the adoption should be competent to go in adoption. As far as the Act is concerned, it is clearly postulated that a child above 15 years is not eligible for being adopted, be it a male or a female. Then the Act also provides that a female Hindu also can take in adoption, provided she is unmarried, she is of the age of majority, she is not, she has not, she has attained the age of majority, she is of sound mind, and the question is, the she can, and or she is a divorcee and she has not got remarried, or she is a widow who has lost her husband, she can also take in adoption. Then the next aspect which is dealt with the Adoptions Act is that an adoption deed, there should be what is called give and take. Biological parents will have to give adoption, and the adoptive parents will have to take in adoption. And then the adoptive child should not be above the age of 15 years, and the adoption deed has to be properly reduced to writing and properly registered under the law. And it is also said in most of the case laws that if the adopted adoption deed is reduced to writing but notarized, it has no value in the eye of law. And second thing is, the question is, who is a stepfather, who is a stepmother? Stepfather is one where a lady loses where a lady is divorced or loses her husband, she gets remarried to another person. Such person is called the stepfather. Or suppose, let us say, the male uh, becomes a widower, he loses his wife but takes in marriage a particular lady. Then in that case, that particular person who comes into the family is called the stepmother. Then the question is, suppose a person has got multiple wives. Then in that particular case, it is said that the consent of the eldest wife will be taken, and she will be deemed to be the adoptive mother. Then the question is, it is also said, for adoption to take place, there should be give and take, there should be competence of the adoptive parents, there should be competence of the biological parents, and the child should not be above the age of 15 years. And the question is, the the consent of both the husband and wife is required in taking in adoption. It is also said in one of the cases that though the wife was present during the rituals, during the ceremony, it cannot be a valid consent. Consent should be explicit, consent should be unequivocal, consent should be unqualified, and should be clear from the vivid terms. And even an adoptive mother can question the adoption under certain circumstances. In another case, it was said that the brother of the adoptive father has got a right of challenging the adoption on various grounds that are available to him under the law, on the ground saying that because of the adoptive child coming into the family, his share in the joint family property is going to be diminished. He can challenge, but how far he can succeed, that's a different matter. Then the question is, trafficking in children is prohibited. That means give and take, that is, biological parents as well as the adoptive parents are prohibited from accepting any money towards the adoption. or making it a business, or aggrandizing themselves at the cost of adoption. And then in that particular case there is a prohibition. It says that the persons guilty can be punished for 6 up to 6 months, and 1000 rupees fine can be imposed. So these are the various instances in which the adoption, and please remember, adoption deed has to be reduced to writing. It has to be signed by the biological parents. It has to be signed by the adoptive parents. There must be give and take. There must be competency of the adoptive parents, competency of the biological parents, competency of the minor who is taken into the adoption, and the minor should not be above the age of 15 years. But suppose, let us say, minor is taken in adoption who is 20 years. Unless the custom and usage in that particular family permits such adoption, the adoption is invalid. And one more thing you must remember is, suppose the adoption deed is reduced to writing, but it is not registered, but it is notarized. A notarized adoption deed has no value in the eye of law. These are all the various facets in which the adoption part was discussed. Then I also discussed maintenance part of it. The question of maintenance is concerned once the wife is deserted or abandoned. The husband is guilty of cruelty. When the husband has another wife living at the time of marriage that has been suppressed, when the husband is suffering from leprosy, where the husband is keeping a concubine, where the husband has renounced the Hindu religion and converted it to another religion, on certain justifiable grounds, maintenance can be claimed by the wife against the husband. Suppose one other instance which we discussed was, suppose a lady loses her husband, the father-in-law is bound to maintain the daughter-in-law from out of his limited resources, and the question is, father-in-law cannot shun the responsibility of maintaining the daughter-in-law. Then the various scales of maintenance. Who are the dependents? Mother, father, son, daughter. Then widowed daughter, divorced daughter, son's pre-deceased son's son, pre-deceased son's daughter, pre-deceased son's great-granddaughter. So all these people come within the definition of the word dependents. And as far as quantum of maintenance is concerned, it depends upon the various factors. The question is the net value of the estate. Second one is the reasonable wants. Third one is the question of what is called um, the question of uh, when they are living separately, justification for that. Then value of the claimant's property, number of persons, regard shall be had to net value of the estate, provision if any made in the will, degrees of relationship, reasonable wants, past relationship of the deceased and dependent, value of the property of the dependent, and any other income, number of dependents. It may be altered or changed from time to time. So these are the various facets as far as the Adoptions and Maintenance, Hindu Adoptions and Maintenance Act is concerned. First and foremost is that this particular enactment, particular law applies only to Hindus. It does not apply to Christians. It does not apply to Muslims. Because as far as Muslims are concerned, there is no system of adoption. What is followed in Muslims is only what is called fosterage. A male child is brought from another family, looked after by the family as if he is the natural son, but he does not get rights of inheritance. But as far as illegitimate children are concerned, though the illegitimate wife is not entitled for maintenance, but the illegitimate children are definitely entitled for a share in the property. So these are the various facets of the Hindu Law of Adoptions and Maintenance Act. And the next class, we'll be discussing the Indian Succession Act. Thank you.